Now I am going to dictate a legal passage based on Law Journal book at the rate of 120 words per minute. Let's start. On his part, Gurnam Singh, plaintiff, was ready and willing to perform his part of the contract and was still willing and ready. The said documents have been duly proved on the file as per statement of PW4 Jaspal Chand Jain, handwriting and fingerprint expert, who had submitted his report after examining the documents and comparing the thumb marks para. There was very reason for plaintiff Gurnam Singh to file a civil suit for permanent injunction, as he had apprehension that vendor dependent Bhartu was negotiating for sale of the same shoot land in favor of some other persons, and they were added as dependents therein. The filing of the said suit itself establishes that the dependents had the knowledge about execution of agreement Exhibit P/1 in favor of the plaintiff para. Learned court of first instance had given specific reasons so as to return the finding that agreement of sale within bracket Exhibit D/1 allegedly executed on 2/4/1988 was antedated. The reasons assigned are that 3 stamp papers valuing ₹1 each was purchased and no purpose for purchase of the stamp papers was mentioned. More so, the stamps were purchased on 31/3/1988, but the same were not utilized on the same day. The stamp vendor could not produce the register for the relevant period whereby stamp papers were sold. The testimony of PW1 Sri M.S. Dhillon, advocate, was not believed for the reasons detailed in the judgment that the said witness was attesting witness in the case regarding wrong identification of Gurnam Singh and Avtar Singh in a case pending before the trial court under sections 420, 467, 468, 471 and 120B IPC para. More so, in the present case there are 2 agreements in favor of dependents number 1 to 4. The first is Exhibit D/1 dated 2/4/1988, the execution of which itself is in dispute, and the second is Exhibit D/3 dated 30/08/1988. In the second agreement, Exhibit D/3, there is no reference to the execution of earlier agreement Exhibit D/1. Even in the sale deed Exhibit D/2, there is no mention regarding execution of earlier agreement Exhibit D/1 para. All these facts clearly establish that the agreement of sale Exhibit D/1 was not duly executed. Rather, the same was antedated and fabricated just to defeat the rights of the plaintiff. Even otherwise, agreement of sale Exhibit P/1 has been duly executed and proved on the file, and the thumb impressions have been duly compared and proved on the file as per statement of PW4 Jaspal Chand Jain, handwriting and fingerprint expert. The court of first instance had given specific reasons for returning findings on various issues which have been set aside by learned first appellate court without any justified ground or valid reason para. In view of the above, the present regular second appeal is accepted, and the judgment and decree dated 24/11/1994 passed by learned additional District Judge Goithal is set aside, and the judgment and decree dated 16/08/1994 of learned additional senior sub-judge Gula is restored. Resultantly, the suit filed by the plaintiff for position by way of specific performance of agreement is decreed para. The regular second appeal stands allowed in the above terms. Stop. Thank you.